क्या आप भी एक प्रॉपर्टी ओनर या नई प्रॉपर्टी खरीदने जा रहे हैं? तो रुकिए, ये वीडियो आपके लिए बहुत इंपॉर्टेंट साबित हो सकती है। तो बात सीधी सी है, मेरे पास जनरल पावर ऑफ अटॉर्नी है, मेरे पास अग्रीमेंट टू सेल है, इवन रजिस्टर्ड विल भी है, बट द क्वेश्चन रिमेन्स द सेम, वेदर आई एम द लीगल ओनर ऑफ दिस प्रॉपर्टी और नॉट. Hello guys, this is Advocate Shivan Sharma here again with another judgment analysis of Supreme Court in the case of Ramesh Chand dead through Elas versus Suresh Chand. इस केस के फैक्चुअल मैट्रिक्स बहुत ही सिंपल एंड इंटरेस्टिंग है. ये केस है दो भाइयों के बीच प्रॉपर्टी डिस्प्यूट का रिगार्डिंग द प्रॉपर्टी ऑफ देयर लेट फादर. तो इस केस में प्लेंटिफ सुरेश चंद अप्रोच करता है ट्रायल कोर्ट contending that he has acquired the property by virtue of general power of attorney, agreement to sale, affidavit and the receipt of payment. वो फर्दर ये कंटेंट करता है that his father has also executed a will in his favor, जो कि रजिस्टर्ड भी है. वो ये फर्दर कंटेंट करता है that उसका भाई रमेश चंद उस प्रॉपर्टी पे एज अ लाइसेंसी रह रहा था. And since the execution of agreement to sale, he has been living in the property as a trespasser. वहीं दूसरी तरफ डिफेंडेंट रमेश चंद, जो कि प्रेजेंट सिविल अपील में अपीलेंट भी हैं, सेटअप करते हैं काउंटर क्लेम कंटेंडिंग दैट हिज फादर हैज ओरली ट्रांसफर्ड द सेट प्रॉपर्टी टू हिम. ट्रायल कोर्ट इस केस में फैसला प्लेंटिफ सुरेश चंद के पक्ष में सुनाता है, अपहेल्डिंग द वैलिडिटी ऑफ द सेट डॉक्यूमेंट्स. Aggrieved by this judgment, the defendant Ramesh Chand approached the Delhi High Court, which again dismissed his appeal, relying on the judgment of Asa M. Jain versus Canara Bank, which later on overruled in the case of Suraj Lamps and Industries Private Limited through Director versus State of Haryana. Aggrieved by this dismissal, the defendant invoked the civil appellate jurisdiction of the Supreme Court. The Supreme Court in the present appeal has gone into the validity of these documents. With regard to agreement to sale, the Supreme Court has examined Section 5 and Section 54 of Transfer of Property Act 1882. Section 54 of TPA defines sale, that the sale is the transfer of ownership in exchange of price paid or promised, or partly paid or partly promised. Paragraph 2 of Section 54 defines how the sale is made. In the case of immovable properties of worth rupees 100 or more, or in the case of reversion, or in the case of any other intangible thing, the property can only be transferred by a registered instrument. Whereas in the case of properties of worth rupees less than 100 can either be transferred by a registered instrument or by a delivery of property. Also defines contract for sale, that is agreement to sale, according to which agreement to sale is an agreement that a sale deed will be entered into between the parties upon the settled term between the parties. It also clarifies that agreement to sale or contract for sale nowhere creates any right or liability upon the property or create any interest or any charge upon the property. The Supreme Court for this referred the Suraj Lamps and Industries Private Limited judgment, held that an immovable property cannot be claimed on the mere basis of agreement to sale, as agreement to sale is not the sale deed. Agreement to sale is a mere agreement where the parties have agreed that in near future they will enter into a sale deed. It does not create any right or interest upon the property. With regard to the general power of attorney, the Supreme Court referred to the judgment of State of Rajasthan versus Basant Nahata and held that general power of attorney is mere a creation of agency in terms of Chapter 10 of Indian Contract Act. It only constitutes the person as the agent for the principal to act on behalf of the principal. It nowhere creates any ownership or nowhere creates any right with regard to the ownership of the immovable property. With regard to will, the Supreme Court has referred to the case of Banker Chala Iyengar and held that the registration of will in terms of Section 18 of Indian Registration Act is optional and the will cannot be acted upon automatically. It has to be proved in terms of Section 67-68 of Indian Evidence Act, read with Section 59 and 63 of Indian Succession Act. Without the proof of genuineness of the will or without the proof of the legality of the will cannot be acted upon. With regard to affidavit and the receipt of consideration, the Supreme Court has held that it is not the accepted mode as according to the Section 54 of Transfer of Property Act. Hence, the affidavit and the concerned receipt does not create any right in the property. सो दैट वॉज द जजमेंट ऑफ सुप्रीम कोर्ट। तो हमेशा ध्यान रखिए, प्रॉपर्टी खरीदते वक्त अग्रीमेंट टू सेल नहीं बल्कि सेल डीड से ही ट्रांसफर ऑफ प्रॉपर्टी होता है। ट्रांसफर ऑफ प्रॉपर्टी के लिए सेल डीड ही एक्सेप्टेबल मोड है, ना कि अग्रीमेंट टू सेल। एंड विल के केस में ऑटोमेटिकली प्रॉपर्टी ट्रांसफर नहीं होती है। बिल को प्रोबेट प्रोसीडिंग के द्वारा उसकी जेन्युइननेस और उसकी लीगलिटी को प्रूव करना पड़ता है। देन उसके बाद ही प्रॉपर्टी का ट्रांसफर होता है थ्रू बिल। दैट्स द लॉ। प्लीज फॉलो जजमेंट जंक्शन वेयर जजेस डिसाइड एंड बी एक्सप्लेन। थैंक यू।